A very good afternoon to all the dignitaries and all the participants present. I, Gnanit K. Hunso from Maharashtra National Law University, Mumbai, will be the comparator for the session. I welcome Advocate Anuj Singh, the chair for the session. It is with great pleasure that I introduce Mr. Anuj Singh, who is a managing partner of Advisor Legal Consultants and Advisors. Sir is a highly accomplished legal professional with a wealth of experience and expertise in commercial and civil law, banking, insurance law, real estate laws, indirect taxation, and litigation expertise. Sir brings a track record of providing comprehensive legal guidance and excelling in regular appearances before multiple forums, including the High Court and Supreme Court. Sir's expertise extends to a wide area. Moreover, Sir has been appointed as the legal advisor, the Urban Transport Department, Government of Uttar Pradesh, showcasing his capacity to handle complex legal disputes at a governmental level. Additionally, Sir is also standing counsel for various government undertakings, which underscores his trusted position within the legal community. Sir, you can speak now. Sir, am I audible now? Yeah.
Yes, yes, you are audible.
Yes, sorry for the brief disconnection, sir.
Yes, yes, no problem.
It is with great pleasure that I introduce Mr. Anuj Singh, who is a managing partner of Advisor Consultants and Advisors. Sir is a highly accomplished legal professional with a wealth of experience and expertise in commercial and civil law, banking and insurance law, real estate laws, indirect taxation, and litigation expertise. Sir brings a proven track record of providing comprehensive legal guidance and excelling in dispute resolution. Having graduated in a Bachelor's of Law from Symbiosis Law School, Pune, Sir has a distinguished career marked by regular appearances and arguments before multiple forums, including the High Court and the Supreme Court. Sir's expertise extends to a wide area. Moreover, Sir has been appointed as the legal advisor to the Urban Transport Department, Government of Uttar Pradesh, showcasing his capacity to handle complex legal matters at a government level. Additionally, Sir has also been appointed as a standing counsel for various government undertakings, which underscores their trusted position within the legal community. I once again welcome you, sir. If you would like
Thank
to begin the session with speaking a few words, sir.
First of all, I would like to congratulate each one of you who is going to present this research paper. And you have been selected or shortlisted for presenting this paper at this highly coveted summit, which is going to be presented and chaired by some of the very legal luminaries. I saw the brochure recently. Even the I think validity is going to be by the Honorable Attorney General. So, congratulations all of you who has been there shortlisted. Secondly, the topic which I saw is very dynamic, relating to the cyber technology and cyber laws. Even last night when I was reading, European Union has got for the first time globally they have incorporated a AI Act yesterday last night. So this is a very dynamic concept which is continuously evolving in India as well as globally. And and the most unique part which I found among the participants were there few are from first year, few are from second year, third year. So that is something very commendable for each one of you that at even before I think cyber law comes in fourth year or third year last, you people have got the research done and got selected and you are presenting the paper in the subject which has not been taught or partially been taught. That is something is very should be appreciated at in a first year, second year you have got into this summit. So yes, and the one thing which I wanted to mark is because the criteria for the evaluation is the time period, and you have to be, I think 10 minutes is granted for each presentation. So try limiting it to the presentation because that is one of the criteria for the evaluation. So so kindly respect the time limit. And if in case something very important is there beyond the time limit, then you can ask for an extension for a minute to wrap it up. I think we are running short of time.
Yes, sir. Thank you, sir. So with this, I would like to call upon the first presenter for the day, Mr. Aditya Bora from Amity Law School. Uh, his topic is From Variables to Inequisites, a look into the complex gender disparities and intersectional dynamics in the landscape of health technology adoption and access. You can begin with your presentation whenever you're ready.
All right, so I think there's an issue with presenting the same. I'll quickly start. Give me a second. I'll just share the same. My
Oh, you
part.
wanted to share the screen?
Yes, sir. I'll just
Oh no,
quickly.
I have the soft copy of your paper, so I can read it.
Not the soft copy, not the paper. I'm presenting the presentation.
Oh, presentation. Okay, okay.
Yes, sir. Give me a second. I'll quickly share. Right. Here's the same. Yeah, I'm not sure why this is not working. I'll share the entire screen, perhaps. If that
You
helps.
can choose the particular tab which you
Yes,
have
it's not
to.
working for some reason, sir. Thereby,
Okay,
I'll share the
I think there's some admin access. Something is there.
perhaps. Kindly let me know if it's sharing now.
Yeah, I can see.
Perfect. I'll play it from start. Right. Can you let me know if this is visible?
Yeah, yeah.
Perfect. I shall begin now. Give me a sec. Yeah. Good afternoon, everyone. Good afternoon, sir. I'm Aditya Bhura, Year 3 Law student from MNLU Law School, Kolkata. This is my topic, From Variables to Inequities, a look into the complex gender disparities and intersectional dynamics in the
Are you
landscape of.
just a second? Whosoever is regulating this, are you going to take care of the timing of the 10 minutes, or I have to take care?
Yes,
Um,
sir. I will drop a message in the chat once the
okay,
time's up.
okay, okay. Aditya, you
Perfect.
can continue.
Yes. So, looking at the complex gender disparities and the intersection dynamics in the landscape of health technology adoption and access. Right. So, coming to the first slide, or rather the introduction of the same. So, the integration of wearable technologies in healthcare signifies a transformative shift, promising personalized interventions for well-being. However, it's imperative to critically assess their impact through a gender lens. Why do we do so? The gender intersects with socio-economic factors, let's say economic factors, cultural norms, and access to resources, influencing individuals' experiences for health technology. Now, this study of mine aims to understand how gender dynamics shape, the adoption, utilization, and the impact of wearable technologies in healthcare, addressing the implications for health equity as well. By acknowledging intersectionality and leveraging inclusive framework, rather, we strive to inform evidence-based interventions that will promote equitable access to health technologies. Now, with an awareness of potential unintended consequences, we also contribute to the discourse on the same. Right. So the research question, as you can rightly see, talks about how do gender dynamics influence adoption, utilization, and impact of health technologies. Right. So moving on, come to the literature review and the things that I found out while going through the existing research on the same. So the adoption and impact of health technologies, especially wearable devices, be it Apple Watch, be it Boat, and all of that, things that have come up, Fitbits for that matter, they have undergone extensive scrutiny with regards to the recent years. So the literature review aims to synthesize existing research of mine into analyzing gender specific trends and disparities in health technology. So it delves into the intersectionality of gender with socioeconomic status, race, and age, offering a nuanced understanding of individuals' interactions with health technology. So, studies consistently highlight gender differences in health technology adoption and usage patterns. For example, let's say women are more inclined to use health apps for diet and exercise tracking, while men prefer monitoring physical activity for sports related metrics. Social economic status also significantly shapes access to the utilization of health technologies, significantly affecting low income women and who rely on affordable or free alternatives. Racial and ethnic disparities further exacerbate inequalities with black and Hispanic women, mostly in the review papers that I researched, they have less access to telehealth services. Next, we find age also compounds these disparities, particularly for older women. One second, particularly for older women facing challenges in health, digital health tool utilization. So, gender sensitive design and implementation of health technologies are crucial to address disparities and to ensure equitable access. Incorporating gender perspectives into wearable devices is essential for to accommodate diverse health behaviors and preferences. So moving on to the findings as to what, after going through all the research papers, what did I find over here, right? So the findings from a secondary data analysis have illuminated the intricate landscape of gender disparities in health technology adoption. So we delve into critical discussion of the same, rather I would say. So first we find the socioeconomic status emerges as a significant contributor, with low income women facing barriers with financial constraints and limited digital literacy. Cultural norms also play a role, with women often prioritizing caregiving roles over their own health. Disparities in access to healthcare and digital resources further exacerbate these issues. Of course, now when we talk about age, its intersection with gender, it poses unique challenges for older women navigating digital health tools due to limited digital literacy again and cognitive decline. Something which is in less numbers when it comes to the male participants as well. So while existing research provides valuable insights, limitations do exist. So perhaps so one of them is, of course, reliance on self-reported data, and of course a focus on Western populations. Very less research is done on Eastern, or the global South, or rather for that matter, Indian population, right? So now to come to the discussion of the same, perhaps addressing these gender disparities in health technology adoption requires a multifaceted approach encompassing policy initiatives, or technological inventions and community-based interventions rather. So drawing upon insights gleaned above, right, which we have found in the previous findings of the literature review for that matter, these are some of the recommendations that I'd like to give, that technology developers should prioritize gender sensitivity in the design and development of health technologies, ensuring inclusivity and relevance to users of all genders. We also need to give in more importance to community based initiatives to improve digital health literacy, so as to empower individuals, particularly women and marginalized communities, to navigate and utilize health technologies effectively. Third, policy interventions are also required to address these disparities in access. Fourth, healthcare providers should deliver culturally competent care that acknowledges the diverse needs of these age groups. Fifth, policymakers should also prioritize on expanding telehealth services and ensure equitable access to all individuals. Sixth, we deal with interventions that should adopt an intersectional approach, thereby bringing in race, gender, caste, all of this into consideration, and disability, of course, into consideration when they're making up these softwares or programs. And of course, more investment needs to be done in research funding and collaboration. So why do I say that before coming to the conclusion itself is because when we look at a lot of medical research that has been done prior to this, we find that women are very less when it comes to participation in these surveys or other experiments that go on, whereby when the product actually comes into the market, it barely recognizes the female needs. Or similarly, for that matter, when it comes to black people, since most of the research participants or rather the experiments are on white people, taking in their experiences, even when it comes to palm recognition, facial recognition for that matter, there have been times when they have not been recognized as humans. So these examples have popped up several times, and again, these disparities in the research and investment in actual working out of the software programming and bringing it down to the market is a great issue that needs to be dealt with. So coming to the conclusion, of course, a literature review shed light on pervasive gender disparities in adopting and utilizing health technologies. Women, especially those from marginalized communities, encounter barriers hindering their access to and use of health tools, perpetuating healthcare inequalities. Key insights revealed factors such as socioeconomic status, race, ethnicity, and age, which intersects with gender to shape individuals' interactions with health technologies. Gender-sensitive design, digital health literacy programs, affordable technology access, culturally competent services, and telehealth policy support emerge as critical solutions to healthcare technology and policymaking, or rather, to promoting equitable access to healthcare. So, by prioritizing equity, recognizing unique needs of individuals, and implementing targeted interventions, we can create an inclusive healthcare system that ensures access to everyone, regardless of their gender or socioeconomic status. So, addressing gender disparities in healthcare access is not just a matter of social justice, but it's also public health imperative, which will drive us towards the future of accessible and empowering health technology for everyone. That is all. These are the references for my paper. Right. Thank you.
Okay. Adit, I have two questions.
Yes, sir.
Firstly, what exactly, because you quoted Fitbits or Apple iWatch, what are the 4 5 technologies you want that should be ideally be included or women centric, which is missing right now in terms of technology, and how while you are doing research, how business viable that is? Because for example, right now the watches are coming at 2000 rupees, 1000 rupees we are getting. So how business viable would be if those technology be included? Because since you are targeting the marginalized community, it has to be in that price range that they can adopt.
Yes.
So the business viability has to be there. It can't be 50,000. Then we can't expect that to be there. So for marginalized community, how business viable that technology would be in that price range, and what all technology is missing in the current scenario? What is the vacuum that is there?
Okay, first I'll deal with what is missing, right?
Hmm.
So let's say when they're performing, or rather when they're taking out these experiments of, then they're testing the samples of these before they're bringing into the market. What happens, so what usually we have done or seen in research, or, all these book reviews that we have studied in Subkush. So we find that, these surveys are mostly done on white males, right? Because, these companies are mostly based in, European nations or, Caucasian nations for that matter. So we find that they barely go into bringing in women into the sample research, or they bring in black people or any other person of color therein. So what happens is, when we, for that matter, let's say pacemakers, a very different example I'm taking in. So pacemakers, for that example, they're made for the human heart of the male only. When it comes to coming and bringing in size of the female hearts, it becomes an issue therein. So that is why female heart attacks after getting in pacemakers are high, if you look at the surveys. So similarly, they do not put in this effort, bringing in all the sex classes or other margin, because the human anatomy differs from race to race, class to class, or sex to sex, for
Agree.
example, right? So this is something that, instead of bringing 100% of one particular demographic, you're bringing, or mix in other demographics as well. That is one thing that you need to bring into the research aspect. Second, coming to the business viability, if you are bringing in, since I addressed that question altogether, what happens is, instead of bringing in samples from one particular demographic, if you're bringing in samples of other demographic and bringing them together, I don't think that will cause in a lot of damage, or more upsurge when it comes to paying them or for the sample size or whatsoever. So the amount spent for collecting data remains the same, so it should not affect the business viability for that matter. What happens after that is, if you implement the same, is it becomes easier, or rather it becomes provides a better structure for your software, and it becomes better for the market as well, so people get better results, better quality as well. So first, it will not affect your price range. For that matter, it should not affect your price range, unless of course there are invested reasons, internal reasons, that you want to increase the price. Second, it makes a better product. And third, of course, it brings in everyone under the ambit of your particular software. So it's only a plus plus situation over here, so there's no
Okay.
negatives per se.
Okay. Thank you so much.
Thank you so much, sir. It was a pleasure.
Thank you. Thank you for the presentation. I next call upon Mr. Nilotpal Singh from MNLU Mumbai, who shall be presenting on the topic herd immunity in women, health, economy, and privacy.
Am I audible now?
Yes, you are.
Yes. Good afternoon, everyone. Good afternoon, Mr. Anuj. It's an honor to be presenting before you. So, my paper is titled Herd Immunity Amongst Women, with special focus on privacy, economy, and health. Now, I'll just share my screen to share the presentation, and then perhaps we can begin. Right. So, I think the PPT is visible.
Yes.
All right. Thank you, everyone. My name is Nilotpal Singh. I am a third year BA LLB student at MNLU Mumbai. So I am in the college right now. But yeah, let's begin. The PowerPoint presentation is largely indicative. What I intend to communicate is through my speech. Now, just to analyze the paper, I believe you have a soft copy with you, sir. The paper is divided into 4 parts. In the first part, I argue what is the case for subsidies. And this I'm doing naturally because there is a debate against it. So since the debate exists, I just wanted to clear it out in the beginning. So part 1 talks about the case for subsidies and the development. Second talks about direct benefit transfers. Third talks about data privacy and subsidies. And in the fourth part, I conclude. So let's just quickly move. This was just to introduce the structure. Let's quickly move to the part 1. Now, why subsidies at all? To begin, let us understand what are subsidies to begin with. Subsidies are a fiscal tool, purely a fiscal tool. Understand it in economic terms as an antonym to tax. Tax is something that the government collects from you. Subsidies is something that the government gives to you. Both of these are fiscal tools. So there is a monetary connotation to both of them. But most of us would have heard about subsidies, at least those of us who are studying, now in the university. And since we are so exposed to news of all kinds, and economic news and social political news, there is a considerable class of people who are against the idea of subsidies now because they think that it is a fiscal burden. But let us understand what is the origin of subsidy and which is discussed, in the paper. And by that, we will do so by tracing the development in economics. Now, India is a mixed economy. By that, we mean that Indian economy has, features of a socialist economy and a capitalist economy. However, we trace the development in the paper by actually showing which of these two type of economies is more dominant. What has Indian society come to become? And I think we all can agree that Indian society has come to become more of a capitalist society and a capitalist economy. This started in 1999 when the Indian markets were liberalized under the prime ministership of P.V. Narasimha Rao, and Finance Minister Manmohan Singh had obviously tabled the revolutionary budget. And since then, our markets have been free. Regulators are decreasing requirements, compliances. Our import and export is much easier. Successive governments have encouraged business. We have special economic zones and all of that. Along with this, all of these are capital virtues, but naturally they shouldn't have affected our socialist aims. But along with this, there's another tendency, the government disinvesting in its PSUs. And that is where we realize that Indian economy is decreasingly socialist. Socialist means government ownership, which is not there. Why this context is necessary? Because subsidies fall objectively in a very narrow sense of interpretation as a socialist fiscal policy. Because socialism says that distribute the resources equally. So then why in an Indian economy, which is tending to be capitalist, why are subsidies required at all? Now, there can be a general essay on this. There can be a sociological study and all of that. Simple answer is that India is a diverse country. Its economy, its politics, and its policies are going to be different because of the populace, the diversity of the populace, the diversity of the issues that we are facing. Why then subsidy becomes important? Now, this we do by contextualizing it in the case of health, which we'll see in the third part of the paper. What were the challenges to subsidy schemes? All of us, some way or the other, we have received some subsidy, directly or indirectly. Latest example to tell you that most of us got our vaccines for free, which was a subsidized program, right? Now, subsidies earlier used to be, you might have been aware of ration shops. So those are an example of physical distribution networks for subsidies. But now what has happened is a new concept has emerged called direct benefit transfers. This is extremely popular amongst all state governments and central governments, especially after the election of 2014. But why DBT emerged at all? What was the need? Because subsidy schemes were suffering from leakages, corruptions. In 1985, I think there was a very, now famous statement by the then Prime Minister that for every 1 rupee that the central government gives, only 5 paise reaches the beneficiary. So in context of these leakages, let us now understand what did direct benefit transfers do and what it is basically. Direct benefit transfers means the direct transfer of financial assistance into bank accounts. Critical focus on bank accounts. So what it has done is it has created financial infrastructure in the digital form, which cannot be tampered with otherwise by agents or intermediaries that were present in the physical distribution networks of previous subsidy schemes. What happens is the government identifies, these are the steps which culminate into a DBT. Acknowledge issues being faced by the society. What is exactly the issue? It may be hunger, it may be a disease, it may be fertilizer subsidies, whatever. Identify target beneficiary. It should be a class of citizens, it should be a class of persons. Third, put in place financial infrastructure. And fourth, release financial assistance in a staggered manner. Now, what do you mean by put in place financial infrastructure? Open bank accounts. Bank accounts in the name of targeted beneficiaries. Now, the paper goes on to discuss actually the health amongst women. So in this case, the bank account has to be, opened in the name of the woman. so that she has financial independence. And just to draw a parallel, in the housing scheme, which is extremely popular in the states of Uttar Pradesh, Bihar, and elsewhere, houses which are being built under the central government scheme, they are being named after the women of the family, so as to create financial independence. So that is the advantage of DBTs. And then whatever financial assistance it is, 5,000, 10,000, depends on the scheme. It will be released in staggered manner. Immensely popular, ladies and gentlemen, 310 DBT schemes as of today, run by 53 ministries. And Ministry of Health and Family Affairs takes the 20th spot. So it's not even taking the highest spot. But now we'll do a case analysis as to which is the scheme which has taken, the spotlight, at least in the paper. So the next slide is about health and subsidies. Now, why talk about health? Apart from obviously it being an indicative theme of the paper, is right to health a fundamental right in India? Right enshrined in the Constitution? Most of us, since we are in the third, fourth year of law school, we will agree, yes. Article 21 guarantees us right to life, and right to health forms a part of right to life with dignity, which is there. However, is the right to health, the nature of right to health granted to us in India similar to those granted in the United Kingdom? Do we have an agency, that can be that's similar to National Health Services of Britain? No. Health is not a free commodity to anybody in India. And the health sector is highly privatized in India. I live in Maharashtra. Those who belong to Pune and Mumbai, they would realize it's so commercialized. But nevertheless, right to health has been recognized as a fundamental human right by the Constitution under Article 21, implicitly by the Supreme Court in various judgments. And also it is the general understanding. That is what the ethos of the country indicate, ethos of the political nature of the country. And hence, I derived the case study of Pradhan Mantri Matru Vandana Yojana. Now, this Yojana, this scheme, ladies and gentlemen, is for pregnant women and lactating women. Financial assistance will be given to women who are pregnant or lactating. A financial assistance is of the nature of 5,000 to 10,000 rupees. It depends on which state, and states can amend that amount. What happens in this is that the program collects data about the beneficiary. What is the primary source of this data? Mother and child protection card. This is a document, primary document. Amongst other information about the beneficiary, it can it has information about the last menstrual cycle, which indicates the stage of pregnancy of the beneficiary. Now you understand this data collation. I'm sure all of us have read about the debate around the DPDP Act of 2023. All of this, since it is being taken digitally, and if I'm running out of time, I request the chair to grant me another 5 minutes. I'll try to compress. But this data can be classified as digital personal data. Personal data, what does it mean? By DPTB Act, the section defines personal data as data through which the beneficiary can be identified individually, which is there in this case. So this is not just data, this is personal data entered digitally. Hence, it is important to discuss the digital, the DPDP Act of 2023, which the paper goes on to do. Because if the government is doing this, if the government is collating the data, the $1 million question is, does the DPDP Act apply to the government? Now, I understand the act is not in motion. The rules have not been notified, but they will be surely this year. So it is only prudent to think of it in that way. Now, data privacy and subsidies is the third part where we discuss DPDP Act. What is the digital personal data? We have discussed in the current case. Now, there are two terms, data fiduciary and data processor. Data processor is the one who is processing the data. In our case, will be government agencies, whether it be central government, state government, or whichever agency. Data fiduciary is the set of all data producers who ensure that the data is not compromised with. I'm not able to see the screen, Nanit, so you might have to unmute and give me stamps.
I think the time is there. So I think you take 3 minutes would be sufficient for you.
Yes, sir. 3 minutes. Yeah. This is the last. Now, what are the safeguards provided in the DPDP Act? You need to have a data protection officer. There needs to be, I'm sure the rules will lay down multiple compliances. Now, all of these will have impact on small businesses. They do not have enough resources. Big businesses will adapt. There are heavy fines mentioned in the DPDP Act, and there is a stellar parallel. It was discussed in the plenary session this morning. A gentleman from UAE had come, and he was highlighting a similar act. All of that is fine, but answering the $1 million question, does the DPDP Act apply to government agencies? It does not. So a section in the provision in the DPDP Act exempts any institution, for that matter, government institution, from any of the provisions of the Act by a notification of central government. Now, this may be in every kind of interest, national security or many other reasons. Now, to us traditionally, this was seen like a roadblock. Ab kya hoga? So the data is not, liable to be protected by the government. And we tend to, in the traditional sense, try to see it as a dispute with the government. People will go to the Supreme Court and say that, no, protect our data. But that is not how it should be. The solution to every legal problem does not lie in law. Let us look at the solution that technology will give us. Blockchain technology. What is blockchain technology? It's huge technology. Like law students, you're usually oblivious by the in-depth nitty-gritties. What does block technology basically does? It's a decentralized set of information. Whatever transaction there is, it becomes a part of a block. The next transaction adds as another block to the block. And once this transaction happens, the second one, you cannot access the first one in any manner. Once you enter information, it is entered and you will not be able to access. Only accessible by one party, which in this case may be the government. Now, just to, for those who are not able to still understand, Google Forms. We enter information in the Google form and then it gets submitted. And unless you're given the option to view the responses, you're not able to review the responses again. Similar in a different way, but this is just a logical parallel I'm giving. But can blockchain technology be used in the case of DBTs? Has this actually even happened? Otherwise, this would be just be an imaginary paper. It has happened. Niti Aayog released a discussion paper in 2020. And it said that the blockchain technology has been introduced. The paper discusses that in the case of fertilizer subsidies. So when you're, releasing subsidies in the case of fertilizers, you need to collect land records. You need to collect, data about all kinds of personal data about the farmers and the crops that are being grown. And blockchain technology was used in that case. So the solution to a legal problem right now lies in harmonious construction and on the basis of technological apparatus like the blockchain technology. So with that, I will conclude. Subsidies are here to stay. No matter how capitalist it becomes, India is a diverse state. I belong to Bihar. You cannot say that Bihar is a capitalistic society or economy. It's very far from that. We cannot even say that socialism has been ingrained in the society. The effects are not there. Public health infrastructure is in miserable shape. So if you withdraw society, fiscal tools like subsidies from those portions of the society, it will become very difficult. But DBTs are the only way forward. Return to the physical mode of distribution subsidies, we might end up in the roadblock. Healthcare subsidies must reach peripheral sections on priority. What are peripheral sections? As discussed, women. There's a popular term, Antyodaya, Antahadika Udaya, Sanskrit Sandhi it is. Panti ke ant mein jo khara hai, uska uday hona chahiye. So with respect to healthcare would reach the man of the family, the head of the family, the children, then the mother. That should not be the case. Third, and finally, data privacy safeguards must be constructed in a harmonious manner using available technological apparatus like blockchain. So with that, I conclude. And Anuj sir, questions from
Uh, Thank you, Nirupal. Did you consider any aspect of Ayushman card scheme while you research?
absolutely. So
What are your inputs on that?
So there are cumulative of at least 46 healthcare schemes, and Ayushman Bharat being a primary policy. Now again, this is the same thing that will happen for the Ayushman Bharat card, or the parallel of Aadhaar card. A health Aadhaar card is being proposed for every citizen. Similar thing will happen. Our data will be collected like it is in the case of Aadhaar card. Tomorrow it might even be linked to bank accounts to ensure that subsidies like this reach directly. So again, in this case, now the government is a fiduciary. The government has fiduciary duty to protect this data. And it may adopt similar technologies to protect it. So whether it is with respect to a single scheme or a different nature of scheme, the answer remains that the government may never statutorily have a duty to protect, but it has fiduciary duty, and it's completely possible by decentralizing data collection through blockchain technology.
No. Thank you so much.
Thank you, Mrs.
Thank you for the presentation. Next, I call Prisha Goyal from Jindal Global Law School to talk on the topic data privacy in the 21st century.
Uh, I'll just present my screen. Just a second. Okay, is my screen visible?
Yes, it is.
All right. So, good afternoon, everyone. My name is Prisha Goyal, and I will be presenting on data privacy in the 21st century. So, digital transformation in the 21st century has brought drastic changes in the way we understand, store, and operate data. So, in the mid 2000s, of course, with the coming of the personal computers and the coming of the e-commerce platforms, the way we store and operate data has completely digitalized. The statement "data is the new oil" it emphasizes the growing importance of data in the contemporary modern times. The comparison implies that similar to oil that fueled the economic and industrial development in the past, data has now become a valuable resource. It has become important for organizations, businesses, and governments to take informed decisions. According to statistics, India was placed at the second position, accounting for 20% of the total 2.29 billion data breaches in 2022. Given this backdrop, I feel it is necessary to look at the evolution of data privacy concerns, analyze the challenges, and see the regulatory frameworks that exist, and also look for recommendations. Now, what is privacy? The concept of privacy has existed since time immemorial, and it is not a new concept. For example, in the ancient Hindu texts such as Dharma Shastras, there is a distinction between the public and the private sphere of life. Though the term privacy might not have been used, it has always existed in the society. There have been various attempts to conceptualize the term privacy. The first attempt was by Louis Brandeis and Samuel Warren, who defined privacy as the right to be left alone. So, in layman terms, it refers to someone's right to keep their relationships and their concerns a secret. It essentially refers to a state of being left alone. Uh, Now, challenges to data privacy. First of all, I feel there is a lack of awareness. So, people tend to fill out their personal information and details on various platforms without realizing the possible implications for of their actions. Data brokers, they provide businesses with data for their own monetary benefit. They gain access to this data through various social media platforms, or they purchase the data from other brokers. Then there are cyber threats. They take place when criminals get an access to the victim's computer. This can take place through malware, spam, phishing, ransomware, etc. Data breaches. Data breaches refer to the intentional leakage or exposure of data to the parties which are not authorized to have that data. Some of the notable incidents would be the Cambridge Analytica scandal and the Aadhaar card scandal that took place in India. Surveillance refers to the tracking of groups or individuals without their actual consent. This can be very endangering since it could lead to an intrusion of your personal space and freedom. If surveillance is not regulated in a proper manner, then those who are in power can, manipulate it, and it can also lead to identity theft and discrimination on the basis of, sex, religion, or even your political beliefs. So I believe frequent cyber threats and data breaches, they have a chilling effect on the mental and emotional state of the victims. Such breaches lead to a distrust on the social media, on the media or the data and the digital systems. So this creates a need to look for the regulatory mechanisms that prevent such endangerment of data privacy. Regulatory mechanisms. So, first of all, the GDPR, General Data Protection Regulation, it came into existence in 2018, and it provided a comprehensive framework that would allow individuals to have control over their private information and personal data. Its main aim was to provide an environment where they can have more control over the data that is personal to them. Rights such as right to access, rectify, and erase their data have been granted by these regulations. Now, United States, the US has various federal and state laws, which cover different aspects of data privacy. Unlike the European law, the GDPR, which is a unified framework. So, there are various sector-based laws such as Children's Online Privacy Protection Act, California Consumer Privacy Act, and various state-based laws which have their own requirements to protect privacy. So the structure of data privacy laws in US has their own challenges because many times individuals are not really aware about the obligations, and a lot of sector and state laws overlap each other. Coming to the Indian context, the landmark case on privacy that revolutionized the system was the case Puttaswamy versus the Union of India. The Supreme Court, in its order, stated that privacy is a distinct and independent fundamental right under Article 21 of the Constitution. So, after this, a committee that was headed by Justice Sri Krishna was set up with the sole aim of drafting a protection law for the country. So, after months of efforts and hard work, the committee was set up and the Personal Data Protection Bill 2018 was introduced. However, due to widespread criticism, it was later withdrawn. Now, the DPDP Act, Digital Personal Data Protection Act 2023, it finally was enacted by the president on 11th August 2023. The primary objective of the act was to regulate the processing of personal data while maintaining the digital privacy of individuals. So it has various principles such as consent. It holds consent as the supreme principle. The consent, of course, needs to be fair and in an informed manner. There's purpose limitation, that is, data should be used and collected only for the purpose that is specified while taking the consent. So if the data is used for purposes that was not mentioned in the earlier consent, the consent has to be renewed. And data minimization, only the minimum and the most necessary data has to be collected. It also gives way to accountability and holds in organization responsible for their activities regarding data processing. The language of the act is clear and concise, which helps the stakeholders to the understand the law. It also constitutes for the data protection board. This board is important for the implementation of the provisions of the act, since the board members would be constituted by the union government, which gives government considerate authority over the board. There are some issues with the act, of course. It assumes consent, which is the deemed consent. This feature makes it very easy for the businesses and the agencies to obtain private information of individuals. Thirdly, it the data fiduciary is required to take security measures that are responsible and appropriate to guard against any data breaches of personal data. However, the reasonable security measures are not specified. There should be special consideration of personal data that belongs to minors, and because it can have a really big impact on their well-being. uh, it also breach notification. It refers to the duty of an organization to promptly notify the data protection board and the impacted data subjects of a breach involving personal data. So it is very crucial that precise and timely notification schedule is placed to ensure that effective parties are notified as soon as possible. So a study was conducted among 1,000 companies, and it pointed out that there is a landscape under which there are disparities in compliance of data privacy regulations among organizations that collect data through their websites. So the organizations, they need to raise their commitment to fulfilling the data privacy regulations, And I will now go on towards recommendations. So I believe strict implementation and prosecution should be there because they are the key elements for the effective execution of laws. While the first step could be is enhancing the data privacy laws and building a robust mechanism, the second step of course is implementation. The DPDP Act has provides for uh, high penalties such as breach of up to INR 2.5 billion for not complying with reasonable security safeguards. However, the law would not be effective if the punishments are not implemented, and it would not lead to deterrence. So, of course, strict implementation and prosecution should be there. Awareness, of course, plays an important role in the successful implementation of a law. Raising awareness regarding the data privacy laws would create a citizenry that is empowered and responsible. They would be well aware about their rights and they will take necessary steps to protect their own personal data. Various organizations, I believe, should also take measures to educate their staff about the policies. The third point is there should, of course, be a balance between technological innovation and data privacy. Technological advancements in data privacy have to be balanced because we need the technological benefits from the technological innovations while at the same time maintain our own personal privacy. So, to conclude, privacy is not something that a person is merely entitled to. It's an absolute prerequisite, as it was quoted by Marlon Brando. It reflects that privacy is not a luxury or something that is a matter of privilege. It should be available to every person. It is the foundation and a rudimentary element to the existence of an individual. To conclude, the arena of data privacy in the 21st century is extremely complex as it is constantly advancing due to the new technologies. The need of the hour is a collaborative effort among the stakeholders like the government, organizations, and individuals to effectively implement the data privacy laws, create an awareness to the larger public, as well as periodically refresh the laws in line with the technological advancements that keep on taking place. Thank you.
Uh, yeah, hi, Prisha.
Hello.
I wanted to know since you have suggested regarding the strict implementation, you must have heard of recent, there was a intermediary guidelines by the state under the IT Act. There's the intermediary guidelines considering Facebook, Twitter, and all other social media platform as an intermediary.
Yes.
Do you think the content which is posted on a Facebook or a Twitter or any other platform, the intermediary are liable for that? That they ideally they should be or they should be not. What's your take on that?
I honestly feel that there should be some extent of liability should be there on the intermediary platform because ultimately it's their platform that is being used to spread information. So of course there should be some extent to which they should be held liable, while I believe more of the responsibility should be on the person that is putting out the content and that is making the post, because it is their responsibility, their opinions that they are putting out. Yes.
Okay, okay.
Thank
Thank
you.
you. Thank you so much.
Welcome.
Thank you for the presentation. I now invite Sangeet Krishna GS from Government Law College, Ernakulam, on their topic Safeguarding Secrets in the Cyber Age, a comprehensive analysis of contemporary data privacy.
Hope I am audible and my presentation is visible.
Yes, yes, yes.
Yeah. Thank you, sir, and thank you the organizers for giving an opportunity. So my topic is safeguarding secrets in the cyber age, a comprehensive analysis of contemporary data privacy. So these are the research questions of my paper. But due to time constraint, I will briefly explain what are all the main contents of these research questions. I will identify the past, present, and future time frame of the data privacy. That is the history of how the data privacy comes into the picture and the present context. That is the present laws and regulations related to data privacy. And obviously, there are many loopholes in this, and so a future suggestions or how the future laws or regulations should be adopted to take into picture the rising role of artificial intelligence and Internet of Things and new technologies that are emerging. And the research method conducted is comparative analysis of different legal frameworks like GDPR in the European Union and Digital Personal Data Protection Act 2023 in India. So, utility and contribution of the research. So our journey, insights into historical evolution. So our journey begins by understanding how data privacy has evolved. We transition from an era of decentralized analog information to a digital world where data collection is prevalent. As we know that at present, we have digital instruments where communication is made in digital format. To put it in more simple form, now we have that our computer or mobile, everything works in a binary form of communication. That is, information is stored in the way of 1 or 0. But in olden days, this was not the case. Analog communication was utilized, and there was no linking or a linking of the different devices. Each devices have been independent. So there is no exchange of information from one devices to another. But in present age, due to the rising of cloud computing or transfer of communications from one instrument to another, the or connection to a main server, etc., there is the transfer of information from one devices to another. So this has resulted in the more rising prevalence of data privacy issues. And identification of present day challenges. Today, we face various challenges because organizations and even government entities collect vast amounts of data and raising concerns about its usage and control. And data breaches remain a threat, and emerging technologies like artificial intelligence and Internet of Things introduce new complexities. Individuals are increasingly aware of the risk and demand greater control over their information. So, the role of legal frameworks. Legal frameworks like the GDPR in the European Union and DPDP Act in India play a crucial role in safeguarding privacy. They empower individuals with control, mandate transparency and consent, and hold organizations accountable for data breaches. These frameworks are still evolving, and this require ongoing adaptation and harmonization across borders. Next, guidance on navigating complexities. Individuals and organizations can navigate these complexities by understanding the rights and responsibilities. Transparency in data practices is key, along with informed consent and anonymization techniques where appropriate. Integrating privacy by design principles into system and process is also crucial. So, as we know that as of now, consider our mobile or any other devices like laptop. Uh, this collects information by default without asking most of the devices without asking our permission itself, and we have to that to stop collecting the information we have to object to it. But the point put forward in this paper is that each devices, whether any devices, should have privacy by default. Actually, that is, there should be an inbuilt respect for privacy, and only after an individual gives consent, that is, he should give consent, and only after that information should be collected, not the other way around. Then insights into emerging technologies. Emerging technologies like artificial intelligence, blockchain, and privacy enhancing technologies offer both opportunities and challenges for data privacy. They can enable secure data sharing, decentralized storage, and enhanced protection. but also raise concerns about algorithmic bias, because these algorithms are created by individuals, and their bias will naturally move on to the algorithms which they create to run the programs across the our Android software or any other operating systems of laptop. Then surveillance and data interference attacks. So understanding these technologies and their implications is essential. Now, a future for data privacy. Looking ahead, collaboration and unified approaches across borders are essential, because we are moving to a more and more globalized world. So there is no restriction of border for data transfer. So a collaboration and unified approach across borders are crucial. We also need strong regulatory frameworks, harmonized standards, and best practices to address emerging challenges. The collaboration among stakeholders, including governments, business, and civil society, is essential for fostering trust and responsible data management. Then promotion of collaboration and accountability. Data privacy cannot be tackled by individual or organizations alone. We need collective action to promote collaboration and accountability. This includes sharing information and best practices, developing global frameworks, and establishing mechanisms for smooth cross-border data transfers. Because all the this should be just a top to bottom approach. Instead, the framework should be adopted from a bottom to top approach, where the ideas or suggestions of the entire stakeholders should be collected. Because this isn't just a legal framework issue, there's a involvement of highly complex technological aspect regarding this data privacy issue. So all the stakeholders like technologists, engineers, or even the common consumers, or even the common citizens, all people's suggestions, etc., should be considered. Likewise, a bottom to top approach should be done to framework a multifaceted, comprehensive data privacy regulation. Next, tentative findings or suggestions. First one, a need for enhanced data protection measures. Data protection measures need to be continuously enhanced to keep pace with technological advancements and evolving threats. This includes robust security protocols, data breach notifications for individuals to access, rectify, and erase their data. Organizations must understand and adhere to evolving data privacy regulations, while governments and regulatory bodies need to enforce these regulations and hold the violators accountable. Then, promotion of ethical data practices. Promoting ethical data practices is crucial. This includes using data for legitimate purposes, obtaining informed consent, ensuring transparency in data handling. Integrating privacy by design principles into technology development and data analytics. Privacy enhanced technologies like homomorphic encryption. This is similar to the ECAS systems like we use in transferring amount, etc., where the entire information need not be decrypted. Just because the fiduciary who is acting as an intermediary need not know the entire details of a transaction, just the transaction from which account to the beneficiary account, that information only need to be passed. So utilizing this technology of homomorphic encryption will allow the sharing of information which are not necessary for initiating the transfer. And federated learning offers is another technology that can be adopted. So this technology will help to reduce the transfer of data from one country to another country. At present, we know that each machine are trying to collect data and learn. Machine learning is the present technology that have been utilized by various companies. So the idea put forward is that consider a server located in India. This machine that is located at the peripheral end of the network shall collect the data and learn from them. This while this machine need not share the data collected from India to another country server. Only the learned outcome shall not be shared. So utilizing this technology of federated learning offers will try to reduce the transfer of data across borders and sharing the data which is not necessary. Then collaboration and knowledge sharing. Collaboration and knowledge sharing among stakeholders are key. This includes governments, business, research, and civil society organizations working together to develop solutions, share best practices, and identify emerging challenges. Then investment in privacy, education, and awareness. So investing in privacy education awareness campaigns is essential. Individuals need to understand their privacy rights because first individuals need to be educated about because people should know that data is not free, data is in no oil. So the first and foremost is that education and awareness should be made to all the stakeholders involved. Thank you so much.
Yeah. Hi, Sangeet. I wanted to know, have you gone through
Yes, sir.
while you research the current personal data protection bill act?
Yes, sir. I have a limited knowledge on that, not a comprehensive knowledge, sir, but little bit, sir.
Okay. No, I thought if you have gone through, if you have any suggestions for that, what changes you would expect, or what is the gray area which is missing, the government has missed while enacting, if you have any suggestions.
Sir, actually, as I have done a comparative analysis in the context of Indian Act, it does not specify a time frame for personal data breach notification, sir. So while
Okay.
the GDPR Act has, I guess it is around 72 hours, sir. So there is no notification regarding data breach. So that should be incorporated.
Oh, okay. Thank you. Thank you
Thank
so
you so
much.
much, sir.
Thank you for the presentation.
A very warm afternoon, everyone. Ma'am, can I proceed with my presentation since no one is presenting? Sir?
I think yes, you can start. I think they have got disconnected or something.
Shall I start? Okay,
Yes,
sir.
you can.
So, a very warm afternoon. Am I visible, sir?
Yes, yes.
So, a very warm afternoon, everyone. It's my absolute honor to be presenting before this virtual summit, which is a very coveted summit organized by Maharashtra National University. It's my absolute honor to be presenting before you, sir, Mr. Anuj Singh. My research topic The title is about the evolution of India's data privacy regime, a critical assessment. And the presenter has used doctrinal research methodology to kind of assess what Indian legal framework is about. Indian legal framework is about data protection, data privacy, and how. Firstly, I will be dealing with why it is needed, why India lags behind. I will be dealing with in the last part, and in the middle, I'll be dealing with Indian Penal Code, which are the sections which are indirectly linked with this whole thing, and then I'll be going into the mother enactment, that is the IT Act 2000, along with the 2008 amendment. Then I'll be delving deeper into the IT rules, and then the most important part, that is the Digital Personal Data Protection Act 2023, and I'll be just going into certain lacunas that that particular act holds and my suggestions. So I'll be presenting now.
I think you have muted yourself.
Am I audible now, sir?
Yes, yes.
Sorry, sir. Sorry. Uh, the title of my research is The Evolution of India's Data Privacy Regime, a Critical Assessment. In the landscape of a rapidly evolving world, profound shift has taken place. We find ourselves in the midst of the information era, where the power of knowledge and the dissemination of information have become the driving forces shaping our society. The world is now more connected than ever before. But what I want to establish over here is the world is now more connected than ever before. And what we proudly say that now the world has become a global village. Everything is connected. What happens in US, we know it in few seconds, within an hour. What has happened in US? What is happening in India? The US people are knowing within few minutes. Every information is there on the Google. But and the social media, since the last few years social media has also boomed, but is it not creating vulnerability? Is it? It is. The world is now more connected, but it is now also it also has become more and more vulnerable. And that's why every country needs to have its own data protection and data privacy legal framework, concrete frameworks, because nowadays cyber crimes are just more and more. There are more and more cyber crimes. So let me proceed with my presentation, that concerns itself with the Indian legal framework. So first of all, I'll be dealing with Indian Penal Code 1860. I'll just dealing everything in nuggets because due to animosity of time. First, Section 464 of IPC deals with forgery. At that time, of course, there was no IT at that time, Lord Macaulay, when enactment was there of IPC. But now it is this particular section, these five sections mostly. There's several other sections, but these five sections are having the application as far as cyber crimes are concerned. First is forgery, Section 464 of IPC. Then forgery pre-planned for cheating, that is section 468 of IPC. Then false documentation, that is section 465 of IPC. Then presenting a false document as genuine, section 471 IPC. And then reputation damage, that is section 469 of IPC. So you must be having the paper. I've dealt with this in depth in that particular paper. Then the mother enactment, that the most important enactment, after which Indian lawmakers also felt, before which in the Indian lawmakers felt that India also needs to have a law governing its IT sector. The mother enactment, that is the Information Technology Act 2000, along with the updated 2008 amendment, which also I feel that needs to be changed. More and more amendments must be there because still we are lacking behind. So first, it is based on UNCITRAL model, UN model. Section 43. I'll be just stating three sections of this IT Act. which I feel the most important, that Section 43 of the Act states that any act of destroying, altering, or stealing computer system slash network or deleting data with malicious intentions without authorization from owner of the computer is liable for the payment to be made to owner as compensation for damages. Second, Section 66 states that the hacking of a computer system with malicious intentions like fraud will be punished with 3 years imprisonment or the fine of 5 lakh or both. Section 66F states that cyber terrorism affecting unity, integrity, security, sovereignty of India through digital medium is liable for life imprisonment. Then in information technology intermediary guidelines and digital media ethics code rules 2021. First it was, I guess first it was in 2003 first these rules were enacted. Then exactly, so these were enacted. Then exactly, sorry sir for switching. Then exactly it was enacted, IT rules 2000 after that. But the latest one is this one, sir. 2000 after that I've just forgot. But sir, main three things of these IT rules 2021, which are the latest IT rules, intermediary guidelines and digital media ethics code rules, are first, grievance redressal mechanism. Second, ensuring online for three objectives of these rules are grievance redressal mechanism. Second, ensuring online safety and dignity of users, especially women users. Second, third, removal of unlawful information. Let us move on to the most important thing, that is the Digital Personal Data Protection Act 2023. Two things I'll be stating. First, consent has to be provided by clear affirmative action. These are all objectives. I'm just dealing it in short. Second, the data fiduciary may process personal data for the data principle only for legitimate uses. Voluntarily shared information, which are, what are those legitimate uses? First, voluntarily shared information. Second, medical emergencies. Third is compliance with any judgment order, of course, of the Court of Justice, Supreme Court, High Court, District Court, anything. Then the regions for India lagging behind. I've just put it in 5 points. First, critical infrastructure vulnerability. Second, financial sector threats. Third, cyber espionage. Fourth, advanced persistent threats. Fifth, supply chain vulnerability. Now, sir, I'm just switching my
I think you
slide.
have 2 minutes left to
So
conclude.
I'll be wrapping it. So So, for example, sir, in 2020, a cyber espionage campaign called Operation Side Copy, Pakistani threat actor was uncovered, which targeted Indian military and diplomatic personnel with malware and phishing emails. Then, what I mean from advanced persistent threats, sir? APTs are complex and prolonged cyber attacks usually carried out by well-resourced and skilled groups. These attacks are designed to infiltrate and remain hidden in the target's network for a long time, allowing them to steal or manipulate data or cause damage. For example, so in February 2021, a cyber security firm called Redico revealed that a China-linked APT group has targeted 10 entities in India's power sector with malware that could potentially cause power outages. Third, sir, supply chain vulnerabilities. Supply chain vulnerabilities refer to the weaknesses in the software or hardware components that are used by government and businesses for their operations. Cyber attackers can exploit these vulnerabilities to compromise the systems and services that depend on these components and cause widespread damage. For example, in December 2020, a global cyber attack on SolarWinds, a US-based software company that provides network management tools, affected several Indian
You
organizations,
have to
including
wrap
the,
it up in a minute.
yes, sir. National Informatics Center, the Ministry of Electronics and Information Technology, and Bharat Heavy Electricals Limited. Then I'll move on to the last slide, sir. Then the way forward and conclusion. First, investigation of the issue of cybercrime legislation in depth. Second, the Information Technology Act of 2008 should be changed. Some modifications need to be there, and there should be greater separation and diversification, sir. And thirdly, increase of the workforce under the IT cells, sir. And fourthly, what I want to add is that what I guess, sir, Presenter Nilotpal said that Personal Data Protection Act doesn't apply to government agencies, and that is a big lacuna, sir. Thank you so much.
Thank you. I think someone named Astha Jain was asking
Yes,
to.
sir. Hi. Good afternoon, sir. Is it okay if I present now?
Yeah, yeah, yeah.
All right. Just give me a second. I'll share my screen. One second. Is my screen visible?
Yes, yes.
Okay. So, hi. Good afternoon, all of you. It is such an honor to be presenting here. So, my topic is Beyond the Binary, Unraveling the Gendered Dimensions of Cyber Harassment in Legal Context. So I think we all are aware of how after COVID-19 pandemic, it has put a halt on in-person events. So the focus has mostly shifted to online spaces. These digital platforms, they offer a liberating avenue for LGBTQIA people to connect, socialize, and network with just a click. But recently, Priyanshu Yadav, a 16-year-old gay boy who used to live in Ujjain, took his life. The reason for such a drastic step was the abuse, hateful comments, and even rape threats he got after posting a video of him wearing a sari. There are millions of similar cases where people who do not fall under the umbrella of usual gender norms are harassed on social media and sometimes even in person. Sexual minority groups have been facing cyberbullying for so long that it negatively affects their emotional and physical well being, which leads to depression, suicidal thoughts, substance of abuse, and even sleep disorders. So in this presentation, I'm going to analyze how there are different laws which has these huge gap on gender cyber harassment, and due to the absence of specific legal provision targeting gender trolling, law law enforcement often resort to invoking sections of IPC, and these provisions fail to encompass the harm inflicted by online gender-based violence. So, to understand how gender harassment is different than the usual harassment, we first have to understand how there is a huge difference between gender and sex. Gender and sex are two different aspects. Gender is not interchangeable with sex, but gender is fluid, which refers to the way a person behaves, their activities, roles, attributes, and opportunities. One second, I'm so sorry. Uh, yeah. In a recent study conducted by S. Marji and Abraham, qualitative interviews where the questions about cyberbullying to a certain number of LGBTQI people were asked, and it was revealed that most people have faced cyber harassment on all social media platforms like Facebook, Instagram, Twitter, and even text messages. In a recent study conducted by a professor in a university where he studied into how memes can touch the toe line of cyber and sexual harassment. There are Memes are a big part of today's generation where all kinds of people try to keep in touch by sharing reels, memes, and posts about certain kinds of people and they dangle on the fine line of cyber and sexual harassment. It is extremely prevalent to come across memes where the creator is making fun of certain genders which do not fit into their usual gender norms. It will mostly contain name calling, morphing the pictures into some obscene picture, creating deep fake videos, etc. Now, what is gender trolling? On May 25th, 2023, there was a transgender activist, Ankita Vadekar. She attempted suicide by posting a message on a 120 group member on WhatsApp. She had joined this community because some people were pretending to be fake transgender. This incident not only refers to the act of using platform to harass, abuse, or discriminate against individuals based on their gender identity or express, but also adds a layer of dimension to the story of abuse when the police enforcement refused to accept her formal complaint. It highlights the challenges faced by victims of cyber threats and also reveals the immediate harm caused by gender trolling. Let us look on how the judicial and legislative has response to this. So the judiciary does not recognize online gender based hate speech because the concept has not been given the statutory recognition. Recently, in the case of Sasikala Pushpa versus Facebook India and others, where her picture of depicting her in the company of a male counterpart from an adversarial political party, the spread of information through diverse social media platforms like Facebook, Twitter, YouTube, etc., the plaintiff had contended that the pro-filtration of such visual content constituted an irreparable violation of her privacy. But while an examination was going on, the court could only help her with the defamation case and could not see as the gender cyber harassment. So, the IT Act, Section 66A to 72, which deals with cybercrime, does not mention the term woman, can be argued to apply to all sets of genders. But at the same time, IPC Section 354C, 354D can only help women and does not mention about non binary people, trans people, or people outside the usual gender norms. But the main question is, are gender neutral laws going to help all norms of gender? Equality emphasizes that all gender receive the same resources or rights, whereas equity means fairness of treatment for all genders according to their respective need. The the legislature has taken a first step towards the inclusivity by the use of gender inclusive pronouns in the Digital Personal Data Protection Act 2023. It isn't just about words, it's about reflection of a growing global trend influenced by feminism in shaping laws. The Act's embrace of gender neutral language builds upon the efforts of past feminism movements, signaling a proactive move to eliminate gender biases woven into our language. There are still some steps that need to be taken by the social media platforms. Users need to protect their online identity using resources like blogs, news, and ISP guidelines. ISP should establish response team well versed in human rights law, responding promptly within 24 hours of receiving a complaint and taking actions tailored to personal harm suffered by the victim. Legislative framework need refinement to effectively address gender harassment comprehensively within the context of freedom of speech in the internet age. Presently, existing laws lack direct mention of gender-based violence perpetrated through the information and communication technology, reflecting in a critical gap in legal framework. Legislative amendments should be explicitly incorporate provisions addressing online violence, recognizing the distinctive nature of the harm inflicted. Moreover, a substantial increase in survivor centric resource and support is paramount to meet the growing demand, particularly in the aftermath of the heightened cases reported during the COVID 19 pandemic. So, in conclusion, legal strides in LGBTQIA rights highlight cyber harassment and the need for improved legislation. Gender dimensions exacerbate offline inequalities, posing intricate challenges. Case narratives like Sasikala Pushpa versus Facebook and others, it demonstrates limited recognition of gender-specific cyber harassment. Collaborative efforts are crucial to combat technology-facilitated gender-based violence in India. Thank you so much.
Astha, did you get chance while researching to go through the upcoming criminal law which are there, BNS, which is going to be there? Is there any
BN,
provision?
the
BN.
new the where they have compiled the all three laws into one.
Yeah, no, there are three different courts are there. So Bharati Nya Sanhita, which is a replacement for the IPC. So did you
Yeah,
get chance?
yeah.
Is
Mhm.
there any provision relating to such harassment which has been addressed in your research paper?
I feel like I might have missed upon that one, and I feel like I should have gone through that. But yeah, it was a mistake on my end. I should have. I think I used my previous case law research for this previous IPC sections and all. But yeah,
Okay,
no,
okay.
I've
No,
not gone through that.
no, sure, no, sure. Thank you so much.
Thank you so much. It was such an honor. Thank you.
Is there anyone ready or wish to present?
Yes, I can present.
Yes, yes, you can.
So, can I present my PPT?
Yes, yes.
Just a sec. Sorry, sir, due to your technical difficulty, I'm not able to present the PPT. Just a minute.
If you can open on your slide because I have a research paper, so you can speak. That is not an issue.
Okay, sir. So got it. Should I start?
Yes, yes.
So when I started writing on the paper, one of the few things that caught my eye immediately was news media and media overall. So media diversity dilemma in India is a huge issue according to me. As in, like, we can see that in today's political era, there is quite a dearth of genuine news that is present in the political discussions as well as legal discussions. Ever since there has been a rise of news channels and journalism that is not particularly fact oriented, and that is not very close to rationality and ethics in any way. So if we take a look at what happened in USA and draw a parallel to that in Indian context, so we can see that ever since the emergence of Fox News, there has been a huge amount of opinions presented as news. Now, this is a big problem, democratically, legally, as well as ethically. Further, if we look at news and media today, there are uh, two kinds of people who do journalism and news. So there's one kind of people that are completely goal oriented. They have to achieve something. They do not care too much about economic or monetary gains that they are going to have from the media and the journalism they do. But they definitely are hoping for kind of a social mobility when they are doing journalism. So for example, if a journalist is honest and wants to uh, present his views on any political or legal or social topic, he definitely will not think about the monetary gain or the fame that he is going to gain from the particular story he covers, but he definitely hopes for the social mobility into metropolis and in high class of the society. And the other group is that they will present anything that is told to them, which will fend them monetary gains as well as personal gains. So, between these two groups, somewhere ethics and morals are lost, and that is one of the primary reasons I feel that in the modern contemporary world, there is no benchmark or no standard that can be compared to as a genuine fact. That is the reason fake news is such a topic and such a big point. And ever since the emergence of AI, it is going to be even more relevant. Further, uh, further, sir, when we talk about India, so uh, those two groups are there, but at the same time, there is political pressure on the media houses as well. So they have political pressure, they have institutional pressure, and as we know that news and media is heavily institutionalized. You cannot open a news channel. There is a heavy censorship. There are defamation laws that can be enacted against journalists, and in the recent past, there have been journalists that have been arrested because of going against the status quo or the establishment, as we say. So media that at one point of time was the fourth pillar of the democracy is no longer there. And one of the reasons I feel that it has come to this stage is that there is no diversity in journalism, in the sense that no matter who or what, there is a slight level of elite in the media institutions, where people from diverse backgrounds are not able to break in, and create stories and create news that is helpful in all aspects to their community and to their own people and society overall. So all of these factors contribute to a media that is not having any uh, personal stance of its own and is under heavy pressure and heavy influence of businessman, politics, and other factor among all. So this definitely impacts the legal as well as the democratic values of the country. And I feel that some of the problems were acknowledged in the recent past ever since the bureaucratic and institutional media started to crack down because of political pressure. And as YouTube media grew, like journalists started uploading their videos and their everything on YouTube and other social media platforms. So now that bureaucratic and political pressure is even extended to the social media and the alternate forms of non-institutional news. So I feel that in the current like present times, the problem of diversity, where social media and technology helped in bringing people to the field of journalism, where any person anywhere could share his side of the story through social media, and acted as as a individual journalist, is coming to an end because of the new bill that will definitely impact the independence of the social media and the journalistic aspects of those things. So this was the main point of my paper, that institutional and bureaucratic pressure is now going to be extended to social medias, and hence there will be hate news, there will be fake news, and these issues are going to get bigger and bigger. A few of the recommendations would be again on a theoretical and ethical level. So all those could be implemented, but right now there is no short term solution for it. Thank you.
Thank you so much. Is there anyone left?
Hello. Yes, so we are waiting on the queue since some
Oh,
time.
yes, yes, you can start.
Sure, sir. Sir, is my slide visible? Hello.
Not, yeah, yeah, now it's visible.
All right, sir. Good afternoon, everyone. I am Shabir Ahmed, and alongside me is my co-author Anshika Malik. Together, we have undertaken a thorough examination of a contemporary issue that has garnered significant attention in recent years. Sir, in the ever-evolving landscape of online platforms, there has been a notable surge in those catering to adult content. Notably, OnlyFans has emerged as a prominent player, particularly in capturing the interest of audiences in India. Today, we are here to dissect the multifaceted impact of this burgeoning phenomenon, and our exploration will traverse the realms of social dynamics, legal intricacies, and ethical quandaries it presents. We'll delve into the complexities surrounding free speech as well as the implications for women's rights. Moving on, sir, our research explores several key areas relevant to understanding OnlyFans' influence. We focus on the experiences of those who create content, analyzing the motivations and concerns they face. Moreover, we examine the preferences of those who consume such content. Crucially, we will be investigating how platforms like OnlyFans are reshaping traditional industries centered around adult content. This comprehensive approach is pivotal to understanding the far reaching effects of the platform. Sir, in India, adult content falls under the jurisdiction of a complex legal landscape. Statutes like Section 292, 293, and 294 of the Indian Penal Code, as well as the IT Act 2000, play a pivotal role in regulation of obscene content. It's important to remember that these laws predate the internet era, raising intriguing questions about the enforceability in our digitalized world. Uh, the when we consider the laws under IPC and IT Act 2000, with respect to this platform such as OnlyFans, it becomes very obvious that they are quite predating to regulate the content that is being broadcasted in those platforms. So this is one issue that needs to be kept in mind while amending these acts in the future. Furthermore, Your Excellencies, court cases have been instrumental in clarifying how obscenity laws are interpreted in relation to OnlyFans and similar platforms. For instance, the case of Google India Private Limited versus Vishaka Industries affirmed the necessity to respect individuals' right to privacy and protect them from unwanted dissemination of sexually explicit content. The ongoing dialogue around legislation is essential to determine boundaries and strike a balance within India's evolving digital landscape. Thirdly, coming to my third slide, we talk about balancing freedom of speech while regulating content on platforms that are being broadcast on such platforms. Uh, in the In this context, Article 19, Clause 1A of the Indian Constitution guarantees freedom of speech and expression subject to reasonable restrictions than Article 19, Clause 2. However, when we talk about platforms such as OnlyFans, wherein creators can perform a number of acts to earn money, it comes within the purview of whether it is their freedom of speech or whether it comes under the obscenity laws that the country governs. So in this particular case, we have the case of Ranjit Udeshi versus State of Maharashtra, wherein the Supreme Court upheld laws against obscenity while acknowledging free speech rights. So the Supreme Court always had tried to maintain a balance between free speech as well as the obscenity laws in the country. Now, similarly, in Ajay Goswami versus Union of India, it introduced the contemporary community standards test to emphasize that the right to privacy, including private intimacy and sexual expression, are crucial facets of the right to privacy under Article 21. So these cases shape discussions on OnlyFans and similar platforms, necessitating a balance between community standards, potential harm, consent, and freedom of expression. And similar debates have been ongoing in the United States in cases such as Miller versus California and Billy Jenkins versus State of Georgia, which offer insights emphasizing local standards for obscenity while highlighting the complexities of protecting free expression even when content is sexually explicit. The legal landscape concerning freedom of expression platforms like OnlyFans in India is complex. This is particularly because India is a country that values traditional ethos and norms to very high regard. And when we talk about platforms such as OnlyFans, it becomes in a country like India, it becomes very hard to even understand how these platforms will be operating and generating revenue in a country like India, which is so much concerned about traditional norms and ethos. So, while we understand the working of these platforms, we need to keep in mind that instead of putting a blatant ban on such platforms, we need to create a balance between freedom of speech and the rights of and the laws that are being defeated in the garn of the balancing this freedom of speech. So now my co-author shall be taking you forward with the women empowerment which is being going on through OnlyFans, and we should proceed.
Good evening, sir. My name is Anshika Malik, and I will continue this. OnlyFans and other am I audible?
Yeah, you're audible.
Hello.
Yes, you are audible.
OnlyFans and other similar platforms can bring a level of agency for women seeking a unique path to content creation and financial independence. Women have more control over the way they are depicted and can monetize their work directly, a power traditionally not readily available in the adult content industry. It is important to note that while there are possibilities for women empowerment, challenges do exist. Platforms and creators must take significant steps to enhance security and prioritize age verification mechanisms. This would aid in minimizing both the authorized distribution of content and any potential exploitation. One of the main hurdles in regulating digital adult content in India is the definition surrounding obscenity. Subjective interpretations can result in inconsistent enforcement. Moreover, platforms such as OnlyFans operate transnationally, further complicating enforcement enforced within the India due to varying laws in different jurisdictions. Furthermore, the sheer volume of online content poses significant hurdles in terms of comprehensive moderation and regulation. It's imperative to prioritize the enforcement of women's protection laws to curb harassment, non consensual content, and to protect vulnerable individuals. In current moment, India's approach to governing adult content is continuously adapting to an ever-changing digital ecosystem. It's crucial to strike a balance between protecting individual rights, addressing issues of exploitation, and respecting a range of societal standards. We can only manage these complexities through continued, comprehensive, and respectful dialogue among policymakers, creators, ethical bodies, and the public at large. We thank you for your time and we welcome your questions and feedback.
Thank you, sir.
Hello.
Yes, sir. So are we audible?
Hello.
Yes, sir. Yes.
So you have actually taken a very unique topic, and what I would suggest would be to not limit it to just one platform, because I think the Twitter is also involved in a similar controversy and has not been going through the all the checks, and they are also equally promoting the obscenity on their platform without any
Right.
checks. So I would say you should, because since it's a very unique topic which you have chosen, you should develop it more and take it to the other platforms, social media platforms as well, and not including not just the big one, but also the smaller one. Like I think there's a Chingari app or something.
Right, sir.
These small
Ulu
apps,
app, there is another
yeah,
one.
which has a quite a lot dominance in the rural belt of India, and they are also involved in equal such obscene content which is being sold out. So I think you should develop this, and along with some empirical data, you can develop this research paper in a. It would be a very good research, and not limited to just provisions and the judgment. Make it go through the concept. So that would
Sure,
be
sir.
fun.
Sir, due to paucity of the slides in this presentation, we couldn't delve into the context of Chingari and Ullu that has been
Yeah, you put it
working.
in the paper, because
We
that
have,
is
sir.
a,
Yeah.
oh, because that is a very unique thing which you have
Right.
taken up.
Thank you
So
so much, sir.
thank you so much.
Thank you, sir. Thank you.
Thank you, sir.
Thank you so much, sir, for your valuable time, and thank you for hearing all of our presenters. I'm sure your valuable feedback has helped them greatly. Thank you again for joining us.